Welcome to SpringLaw's Spring Forward Legal Updates webinar series. This series is designed to provide a comprehensive legal overview of key issues related to employment law and human rights in Ontario. SpringLaw is a virtual employment law firm advising on workplace legal issues for employers, employees, freelancers, and executives from a wide range of industries. We hope you enjoyed today's webinar and find it useful and informative. To reach our team, please visit us at springlaw.ca. And now to our presenters.
Welcome everyone to our webinar, number 56. This is my first one that I get to take part of today, so I'm really excited about it. When creating this webinar, we were trying to figure out some situations where things are really getting tense in the workplace, and at the same time, situations that are a bit confusing and not handled quite often, for certain employers. And that might be very confusing for individuals to deal with. So we aptly dubbed this presentation "When Stuff Really Hits the Workplace Fan," to both kind of capture those confusing and difficult times, which this presentation will go over. Firstly, Lexa will cover firing for just cause. Contrary to popular belief, you can terminate for cause. It's just very difficult, but not impossible. So we'll go over some of those definitions and circumstances where that can happen. It has happened, to give examples. And then she will also touch on various workplace investigations that could happen as from ministries. So specifically those controlling the legislative power in the province. And then I will be discussing the Occupational Health and Safety Act, specifically workplace investigations and potential regulatory offenses under that statutory regime coming out of workplace injuries or proactive investigations. So that's kind of the structure of this program today. And just to note, we will be taking questions, but you can bring them in periodically, and we'll just cover all questions at the end. So this is me and Lexa. Thanks for being here. And so, as discussed, after the intro slides, Lexa will be taking over, and then I'll pop on after. And before the presentation starts, it's just important for us as a firm to acknowledge that the land on which we operate is traditional territory of the Anishinaabe, Haudenosaunee, Huron-Wendat, and Mississaugas of the Credit First Nation, who have stewarded these lands for generations. We recognize that Indigenous peoples lived and thrived here long before the arrival of settlers, and we acknowledge the lasting impacts of colonialism. As part of our commitment to truth and reconciliation, we strive to learn, unlearn, and understand the history and effects of these wrongs. We are grateful to live and work on this land. And just lastly, before I turn it over, this funny picture kind of explains what I'm about to talk about. I won't read this whole slide, but I will say that anything in this presentation is not legal advice, should not be construed as such, and I apologize for such formalities, but we are lawyers, so we kind of have to say it. So thanks everyone, and I think as for that, we'll turn it over to Lexa.
Awesome, thanks, Phil. Yeah, so let's dive into one of the most complex and sensitive topics in Canadian employment law, understanding just cause for termination. And this is really where we want to put the disclaimer, especially this topic is so fact specific, so dependent on the circumstances of the workplace, the employee. So this is certainly not legal advice, and every situation is going to be different and need to be assessed on its own facts. So continuing with the lawyerly talk there. So understanding just cause. Just cause is the employer's right to terminate an employee without notice or pay when their misconduct is so severe that it irreparably damages the employment relationship. So this is, the nuclear option for employers. Some more dramatic employment lawyers also refer to it as the capital punishment of employment law. So, you could tell by those descriptors that this is an area where we want to tread carefully. So we have 3 sources of a just cause standard. If it wasn't already, daunting enough, we've got 3 different places that you're going to want to look for finding what the actual threshold is that you need to meet to establish just cause. So first is the statutory standard. So we'll mostly be using Ontario as our sort of main comparator today and what we're looking at, but you can look at each provincial legislation for their own standard. But under the Ontario Employment Standards Act, an employee needs to have committed willful misconduct, disobedience, or neglect of duty. So these are deliberate acts that are serious and have not been condoned by the employer. So the employer hasn't explicitly or implicitly, given the employee the green light to do these actions. So honest mistakes or negligence typically don't qualify. The word willful in willful misconduct is a really key point that courts really look to. So it needs to have been essentially being bad on purpose. And this is generally the highest standard of what an employer would need to meet to show just cause. Then we have the common law standard. So the common law is judge-made law. So this is the body of case law coming from judicial decisions. So judges generally look for misconduct that undermines the employment relationship. So the most, clear examples of this are things like theft or violence. They also consider factors like the employee's length of service and whether progressive discipline was used. So it's, again, as I said, it's very fact specific. You're looking at the full situation in its entirety to determine whether just cause has been established. And then the contractual standards. So employment contracts can define just cause, but those definitions need to align with legal principles in order to be enforceable. So it can't be more strict or limit employees' rights more than, say, the statutory standard. And this is where a lot of employment contracts run into trouble, but that's the topic of a whole other webinar for you. So as I said, statutory is the highest standard, meaning there could be an action that qualifies as common law just cause. So the employee would not be entitled to common law notice, but that same employee action could not meet the higher statutory threshold, and therefore the employee would still be entitled to statutory notice of their termination. So there's these different buckets that you need to look at. So to just cause, courts in Canada apply an extremely high standard. Again, as I said, it's the capital punishment of employment law. They look at it very harshly, there's very exacting standards that you need to meet to establish it. So this means that the misconduct needs to be so severe that it justifies termination without notice or compensation. So employers need to proceed carefully in order to meet this threshold. So the key considerations for both you and what the court will be considering are things like nature and severity of the misconduct. So looking at how serious the misconduct is, whether it's one single serious egregious act or whether or an incident like theft or a pattern of behavior that undermines trust. So it can be one single really serious action, or if it's less serious, you would need to show a pattern of it. One less serious instance isn't going to be enough. Impact on workplace or reputation. So the focus isn't just on the misconduct itself, but also the broader effect. So this really, that will come into play in more senior roles, in more public-facing roles, things like that. Past disciplinary measures and progressive discipline. So progressive discipline is really key, especially when you're looking at those less severe, but that pattern of less severe conduct. Courts will ask, did the employer give warnings or opportunities for the employee to improve? So termination for just cause is rarely upheld without prior steps, unless the misconduct is really, really severe. And then level of honesty and integrity in an investigation process. So if you've received a complaint that an employee has committed workplace harassment, you should not just be terminating them right away. You should be looking into that allegation and conducting a thorough, fair, and unbiased investigation. And then ultimately, once you've concluded that investigation, you can decide how to discipline the employee, up to and including termination for just cause. So some examples of misconduct that may constitute just cause. So remember, the bar is very, very high, and the misconduct needs to be severe enough to irreparably damage that employment relationship. So under the banner of serious misconduct, these are things that one instance could likely justify a just cause dismissal. Things like theft, fraud, assault, significant dishonesty. These are examples where the trust is broken so severely that the employment relationship can't continue. The next one is insubordination. So a willful and persistent refusal to follow reasonable instructions may constitute just cause, particularly if the instructions are critical to the role or if the instructions are for the health and safety of the workplace as well. That's something that courts really take into consideration. If it was willful and persistent insubordination, you would want to be documenting that as it goes and giving employees warnings and taking disciplinary action prior to terminating for cause in most cases. Workplace harassment or violence. So harassment that creates a toxic work environment or violates workplace harassment policies. So those would typically, harassment again would typically involve an investigation first. Obviously violence, that's going to be something that really goes to the heart of the employment relationship and also may mean that your other employees aren't safe. So that's something else to really consider. And be looking out for. Chronic poor performance. This is only applicable if it's well documented and the employer has made genuine efforts to correct the issue through coaching, feedback, or additional training. Ultimately, on a practical note, I rarely advise my clients to terminate for cause for poor performance. The amount of effort and time and resources it takes to put into doing adequate progressive discipline and performance management and the coaching that you would need to provide, it for most employees is just not going to be worth it, and it's going to still be difficult to establish in court that you actually had just cause. So that's a sort of cost benefit analysis that you would need to do for each employee. But generally we won't advise pursuing just cause for chronic poor performance. And then finally, conflict of interest is another example. So when an employee's actions harm the employer's business interests, for example, working for a competitor or misusing confidential information. This is, again, it's going to depend on the employee's position and how much access they have to the employer's confidential information, how key they are to the business. A regular frontline employee, these types of things may not apply. So just as a note, courts expect employers to take proportional steps before resorting to termination. This often means, as we've talked about, implementing progressive discipline, such as warnings, suspensions, or performance improvement plans, unless the misconduct is so severe that immediate action is justified after one single incident. So as we've said, it may feel like, when is it ever cause? Can you ever be successful at establishing cause? So we've put together a few cases just to show you the types of situations where cause has actually been made out in recent cases. So the first is Park and Costco Wholesale from 2023. So Mr. Park was a 20-year employee of Costco. So we know that longer tenured employees, it can be more difficult for the employer to establish cause. So that's the first thing to notice. with this case is that Costco would have had an even higher threshold here. So he was fired after intentionally deleting an internal company website he had created for Costco's toy department. So despite his managerial responsibilities and the company's ethics policy emphasizing integrity, he deleted the site twice in anger, including after being explicitly told not to. So this is, deliberate, repeated acts, insubordinate emails, attempts to mislead his employer, and willful destruction, essentially, of company property, right? So that had a lot of factors, and ultimately the court found that the employer was justified in terminating for just cause. Another example that you may have read about in the news is CRA employee terminations for CERB fraud in 2023. So the Canada Revenue Agency terminated 120 employees for claiming the Canada Emergency Response Benefit while employed, essentially committing fraud. So this misconduct directly breached the trust inherent in their positions, right? So they're working at the Canada Revenue Agency, they have access to confidential information, they're given a certain amount of trust and discretion, and that's something that's inherent to their position, and these actions went right to the heart of that employment relationship, and so it couldn't continue any longer. So this is, been cited as an example of how serious dishonesty undermines employment relationships, meeting the threshold for just cause. And then finally, another example was in 2022. So a long-term employee was fired for touching a coworker's buttocks during what he described as a joke. The Ontario Court of Appeal ruled this act of sexual harassment, even if isolated, was serious enough to destroy the employment relationship. The court held that the conduct, compounded by his lack of remorse, supported a finding of just cause. However, the court found that this conduct did not meet the standard of willful misconduct under the Employment Standards Act. So this is an example where the common law, he was found to not be entitled to common law notice, and because he met the threshold of just cause under the common law, but they found it didn't constitute willful misconduct under the Employment Standards Act. So that's a pretty extreme example of the court finding that this was not willful. I'm not sure I understand the decision, but they didn't ask me, so there we go. So key risks and employer best practices. The main risk when you're looking at just cause termination, when you're considering whether to terminate someone with or without cause, is the risk of litigation. So courts scrutinize just cause terminations very closely, as we've been discussing, and the burden of proof falls entirely on the employer. So if your case isn't airtight, you can be facing financial or even reputational costs by having, litigation occurring in the public forum. I always tell my clients, you can almost guarantee you will be receiving a demand letter from a lawyer when you terminate an employee for just cause. It brings the temperature up. It always makes a termination more aggressive and acrimonious. So that's just something to keep in mind. So, if the case isn't airtight, or maybe the cost of terminating without cause is not that high, that's something you may want to consider in your cost benefit analysis of whether to terminate for cause. So best practices, if you are, if you do want to terminate someone for cause, are first to document everything. I think we probably say this in every single one of our webinars, no matter what the topic is, because we're lawyers, but we want you to document everything thoroughly. Thorough documentation is your strongest defense. Keep detailed records of misconduct, warnings, and performance reviews. Without clear evidence, your case may not hold up, right? Progressive discipline is the next one, as we've talked about a lot already. So applying corrective steps consistently. So doing the same thing for all of your employees and applying them consistently whenever someone commits misconduct. Verbal warnings, written warnings, suspensions. and show the employee was given every reasonable opportunity to correct their behavior. They need to be put on notice, essentially, that what they're doing is not acceptable and that they could face termination if they continue doing it. So performance versus discipline, be especially cautious with performance-related terminations. The standard for just cause in these cases is higher and requires extensive, well-documented attempts to support the employee. As I mentioned, it's rarely going to be advisable, but in certain instances, it's going to depend on the circumstances. Fair investigations, so conduct a fair, unbiased investigation into allegations before terminating for just cause. And finally, legal consultation. These situations can be difficult and can expose your business to significant liability. So you want to ensure that you are getting a second opinion in these sort of dicey situations. And just as a closing thought, this is an overarching theme in employment law in Canada and Ontario especially. Courts tend to favor employees in disputes. Our statutory regime, our common law regime is looking out for the interests of employees. And so if you're going to establish just cause and try to convince the court that this employee was not entitled to their entitlements they would have received otherwise, you need to build a strong, well-documented case. So that's the end of just cause. Now I'll chat a little bit about some investigations. So first is records of employment. So records of employment are essential documents that directly impact employees' access to employment insurance benefits. It's typically, a fairly administrative, mundane. It should be happening relatively automatically, but mistakes or delays in ROE submissions can trigger investigations and lead to serious consequences for employers. So, disputes over separation codes, so the code that you put in on the ROE to signal to Service Canada what the reason is for why there's been an interruption in this employee's earnings. That's one of the biggest things we see, and we receive lots of questions about which code to use, and also delays. So employers are legally required to submit ROEs to Service Canada within 5 days of an interruption in earnings. So that's, not only terminations, but temporary layoffs, or if the employee is on sick leave or maternity leave, things like that. These must accurately reflect insurable hours and earnings, and incorrect information can directly affect an employee's EI benefits, increasing the likelihood of scrutiny from Service Canada. So failure to comply can lead to demands for corrected ROEs, administrative penalties, and even prosecution if false information is found, or fraudulent information is found to be on records of employment. So this is, again, it's something that in the day-to-day can seem sort of mundane and administrative and not much thought is given to them, but it's really important that they're accurate and done on time. Failure to, sorry, I already said that part. So practical tips: using automated payroll systems to generate ROEs promptly and ensure accuracy. These systems help reduce human error and keep you on track with deadlines, minimizing these risks of penalties or prosecutions. So it's, it's not just about compliance, it's also really important to employees to get these ROEs quickly, because it means they get access to employment insurance benefits a lot quicker. So it can be really important to them personally as well. So it's just good to implement a system gets that done quickly and properly. ESA breach investigations. So what triggers an investigation? Usually they start with employee complaints, such as unpaid wages, missing vacation pay, termination disputes, high-risk industries like hospitality or construction may also face random audits to ensure that they're being compliant. So Employment Standards Act investigations can catch employers off guard, but it's important to be prepared for them. ESA officers have broad authority for inspections and investigations, so they can review payroll and other employment records, they can interview employees and managers, they can issue orders for back pay or mandate changes to workplace practices or policies. So for serious violations, penalties can escalate significant fines or even legal action, which could harm your business and your reputation. So overall, again, this is a theme throughout: keep thorough records of everything. This includes payroll, hours worked, and vacation accruals. Ensure your workplace policies align with Employment Standards Act standards to reduce the likelihood of complaints or penalties. So I see this all the time. It's not, done out of malice or trying to skirt the law, but sometimes things have been done a certain way for so long, and they're done a certain way because they've been done a certain way. And it's always good to double check that those key practices, wages, wage deductions, vacation pay, things like that are complying with the Employment Standards Act. And train your managers on key ESA requirements so they're equipped to follow and enforce these standards. So proactive compliance isn't just about avoiding penalties, it's about, fostering trust with your employees and ensuring a stable, compliant workplace. These investigations and inquiries, they not only can have financial penalties, but they also can be disruptive, right? So whenever you can avoid them or mitigate them as much as possible, that's going to be your best bet. So now I will pass it over to our resident OSHA expert, Phil, to give us some insights into OSHA breach investigations.
Thanks so much, Lexa. That was a great presentation on very interesting topics that we love talking about at the office. So I really appreciate that presentation. Thanks everyone for having me today. I don't know about OSHA expert, but it's definitely an area of law that really intrigues me and I love to practice in, and many employment lawyers just don't like it and stay away from it, but I kind of really enjoy it. So just to break down today's presentation, I put OSHA into two separate buckets. There's the compliance bucket, and then what happens when compliance wasn't there, right? Or what happens when compliance arguably didn't happen, right? Today's presentation is very much about, like we said, what happens when it hits the fan, right? So we're not going to be talking so much about compliance, but the presentation should enrich people's understandings of how to potentially comply with the Occupational Health and Safety Act, so these types of investigations either don't happen or you're more prepared for them, right? So as for OSHA breaches, the common triggers are workplace accidents, safety complaints, or routine inspections in high-risk sectors. I will acknowledge that this area of law is far more applicable to industries such as construction, warehouses, contractors, right? Just where there's a lot of safety sensitive stuff, mining, right? So it's not as applicable to your standard office setting. However, it is applicable because Occupational Health and Safety Act applies to almost every single workplace in the province. So accidents do happen in offices, also, although rare. Having mechanisms in place to try to stop them is important in every workplace for sure. The more high risk sectors, there are just much higher safety standards due to the obvious nature of the work, right? So I'll get into some of these specifics a little bit more, but the inspector authority in response to a workplace accident is incredibly high. So I'll just do an overview of that, and the potential penalties are incredibly high as well, right? A corporation can face fines of almost $2 million, of up to $2 million per breach, right? And individuals can face really large fines and jail time as well, as can directors, right? Not a lot of jail time, but some for sure. So just a practical tip before we get into the nuts and bolts is to hold regular safety meetings, update training for all employees, and document compliance efforts to show inspectors due diligence in safety management. And a theme I'm going to try to get across in this presentation without it obviously leaking into legal advice is that your policies are only as good as the implementation, right? Because I get a lot of clients that will come in and they're charged with OSHA or other statutory breaches, and they have lovely policies, right? But nobody was following them, right? So that's a real key in this area. So this is the title slide. So just an overview of, oh, thank you. Sorry, I was clicking as if I had control over this, forgetting that Lexa has full control. So thanks Lexa. So just an overview of the Occupational Health and Safety Act. It's Ontario's main legislation for health and safety, right? It applies to almost every single type of employment environment out there. It's just safe to assume that if you employ people, it applies. There are incredibly narrow and small exemptions that just almost never apply. Obviously, if you think yours applies, talk to a lawyer and make sure that's correct. And the employer responsibilities in relation to the Occupational Health and Safety Act are quite thorough, right? They have a duty to take every reasonable precaution to ensure worker safety, to train, for training and supervision, to ensure that workers are trained and supervised, right? And in relation to the employers themselves, there are subcategories of requirements as well, because like supervisors have their own requirements. They can, in these kind of occupational health and safety breach cases, what most often happens is someone falls off a ladder, for example. I have a client that's dealing with that right now. We're about to wrap up the file. Everyone gets a fine, right? The employer got a fine, the contractor got a fine, the supervisor got a fine, right? So they really pick them apart and make sure that everyone's held accountable if there are breaches of the Occupational Health and Safety Act. So another responsibility is important is safety policies and health and safety committees. So if you have more than 6 employees, you need to have policies, right? And if you have more than a certain amount of employees, it changes periodically, so I just didn't put the number in there, you have to have a joint health and safety committee, right? And if you have even more, then there are more responsibilities, right? And the Joint Health Safety Committee needs to have certain kind of members. So one needs special training, and then the rest just need regular training, right? So there are distinct compliance mechanisms there. And if after the fact, after an accident, it's found out that these mechanisms weren't in place, it's a check mark against the employer and in potential conviction under the Act. So, and workers' rights are simple, but they're broad. And it's a right to know, right to participate, and right to refuse. So a worker in Ontario has a distinct right to know about workplace hazards, if any, to participate in the health and safety process. So you'll see in the Joint Health and Safety Committees and other responsibilities that they're very much worker-led. There's management requirement and worker requirement that dovetail into one responsibility. And they have a right to refuse, right? An employee is allowed to refuse any unsafe work or work they deem to be unsafe until it's cleared to not be unsafe, right? And if an employer reprises against an employee for that, for refusing to do that work, which interestingly enough kind of tags onto that conversation of just cause, right? Are they being insubordinate or are they refusing unsafe work? Talk to a lawyer, right? Because it's because reprisal under the Occupational Health and Safety Act is a big problem. Reprisal under the ESA, Occupational Health and Safety Act, or the Human Rights Code is all a big deal, but under the Occupational Health and Safety Act, it comes up a lot when people refuse unsafe work, right? And an employer tries to fire for that or discipline. So thanks. Next slide. So Ministry of Labor and inspections and investigation. So what's the role of the Ministry of Labor in these circumstances? So most commonly, bad accident happens, someone breaks a leg, Ministry of Labor comes in right away. You have to report that to the Ministry of Labor and they come in right away and they investigate, right? Other circumstances are an employee who refused work and doesn't think that the unsafe work is being addressed, anonymously calls the ministry and then they come in, right? So that's another common experience. And increasingly so, proactive investigations are coming back. They were really popular a decade ago. They almost stopped. They didn't stop, but they became very unpopular due to funding in the provincial government, but it's been ramping up again. Since in the last 5 years, the Occupational Health and Safety Act has been amended 3 times about, and all of the amendments have increased the fines and increased the compliance mechanisms and the severity of consequences if you don't comply. And with that increase, with those increases with the amendments, has of course come more proactive investigations. So if you have previous convictions, or if you're in a high risk environment, high risk factory setting, construction setting, and the ministry chooses to, they can just show up, right? They have very broad powers to do that. And if they show up, whether after an accident or after an anonymous complaint or after a proactive search and audit, they have very significant powers and can hand down some serious orders. One of them is a stop work order. So for example, I had a file where there was an injury in a factory setting, and there was an instant stop work order in relation to any work around the machine that the individual was driving and the door that malfunctioned. Could not be used until it was fixed, and showed that it was fixed properly, and the investigator approved that repair, right? And that was in addition to the investigation as a whole that included many compliance orders, right? So there was a stop work order, compliance order, and requirement order, right? So, and the compliance order just sets out a deadline for correcting an identified issue, and the requirement order requests specific documents or information for further inspection, right? Which is very common. So in that file that I was talking about, there was a door that malfunctioned. They wanted to see the manual, right? They wanted to see that the manual was followed, and that is a broad power that they have. And I'll mention this after, because there are some procedural nuances to inspections themselves, inspection orders, and the actual offenses process of being charged under the Occupational Health and Safety Act. 99% of the time when a lawyer is hired on this, it's after the inspection has been completed. Employer thinks they're all good, they're done. A year later, a summons to appear in court with a big, you may be facing a $2 million fine on the front page, comes in the door, and the employer's like, but I already complied with all the investigations, right? And with the compliance orders, doesn't matter. Certain statutes like the Technical Safety and Standards Act state that if you comply with orders, you then can't be charged, but the Occupational Health and Safety Act doesn't have that exemption. They use the inspection process to confirm guilt and then charge you after the fact a year later, right? So there are procedural mechanisms to challenge compliance orders and challenge investigations. But before that process is done, speaking to counsel that has experience in that process is really important, because if you challenge the process illegitimately, guess what? Part of the provincial offenses sentencing model to increase fines is non-cooperation with the investigation, right? So it's almost a damned if you do, damned if you don't. If you challenge the investigation, do it properly through statutory mechanisms, you could potentially not face an aggravating factor, but if you challenge it improperly, you could get a larger fine for not cooperating later down the line. So it's just a very nuanced piece, but worthy to talk about. So moving on. So responding to compliance orders, as I talked about, employers must meet the deadlines in order to in orders or face further enforcement, right? The proactive compliance with orders can prevent escalation. So subject to that nuanced statement I just made, it's very important to comply with every step of the investigation, right? They have broad powers, and if you do speak to counsel or not, and you have the choice of complying with an order, complying with an investigation, or not complying, always choose the compliant part, okay? And impact of non-compliance, the failure to comply with Ministry of Labor orders can lead to fines and further legal action, 100%. And even with compliance, like I talked about, you could face these charges regardless. And that's the charges that I'm talking about are charges under the Provincial Offences Act, right? And these fines and provincial offences charges are known in the legal world as regulatory offenses or pseudo-criminal offenses. So they rub the line between civil and criminal law, but at the end of the day, they're closer to criminal law in the sense that they're not exactly criminal law, but the type the area of law that you use to defend them all comes from criminal law. So that's an interesting aspect to note about that. And some practical advice is that sometimes challenging, like I said, the investigation order themselves is a strategy. This can mitigate how much of a case the Ministry of Labor investigator mounts against you, mounts against the employer for subsequent charges under the Occupational Health and Safety Act. Again, must be approached very carefully, or at the very least, if not challenging it, you can hire a lawyer to guide you through the investigation process so you don't incriminate yourself too much, right? Because they really try to get information out of you in these recorded investigation meetings that basically make their case for them. And there's been recent case law that comes out that says a lawyer cannot impede the investigation process, or they can actually get fined personally, and the employer can face additional fines, but you are allowed to have counsel guide you through the process, so you're not exposing yourself unnecessarily. So the regulatory offenses themselves, right? Violations of the Occupational Health and Safety Act or its regulations, it's usually a specific regulation that's breached after an accident or that caused the accident to happen, or Ministry of Labor orders are regulatory offenses, right? And as discussed, the examples are failing to protect workers, obstructing investigations, and ignoring compliance orders. The most common is an injured worker is found to be injured by lack of appropriate care of the employer, supervisor, contractor, owner, or director. And the penalties for this currently, after the last amendments, are corporation fines of up to $2 million per offense. There are often 4 to 6 offenses in each case. So that's important to note. And directors and officers can face fines of up to $1.5 million now, and/or 12 months imprisonment. And supervisors and other individuals can face fines of up to $500,000 and/or up to 12 months imprisonment. Just to give you an example of the amendments, not that long ago, this individual fine maximum was like $50,000, right? So they've really ramped it up. And just to note, the $2 million per offense thing, it almost never happens. I've yet to look at a case that's fined the maximum per, especially if you enter a plea deal. But it is a possibility, you know, if someone passes away as a result of an injury, unfortunately, and the corporation did not comply with the investigation, had no safety mechanism in play, it is within the court's purview to lay these fines down. So it doesn't happen often, almost never, but it is possible. So it's worthy to know. So what are the strategies to defend Occupational Health and Safety Act charges, right? There are very few, actually, because they're called strict liability offenses. In the criminal world, there's criminal offenses, strict liability offenses, and absolute liability offenses, right? So in criminal, you need both the intent to breach the law and the action of breaching it, right? That's about as much as I know about criminal law. But in strict liability offenses, you don't need an intent. All that matters is that the law was breached. So your intention to breach it doesn't matter, right? So, and in absolute liability offenses, none of it matters. If it happens, and one of those examples is, for example, a truck on a highway that a tire falls off and hits someone. From last time I checked, that's an absolute liability offense. Doesn't matter intent, doesn't matter anything, pretty much no defense available whatsoever. But with strict liability offenses, which Occupational Health and Safety Act charges are, you have what's called a defense of due diligence. There are other defenses, but the only other substantive defense is what's called officially induced error, which almost never happens, which basically says that like a Ministry of Labor inspector told me I could do that and the accident happened as a result of that, right? Almost like never happens, but it's happened a couple times. So, but the only real substantive defense, in short, removing all legalese, is I did everything I could to ensure safety and the accident happened anyways, right? And surprisingly, it's an incredibly high bar to reach, and most employers after a workplace accident don't have that defense available to them. They just don't reach the high standard of being able to prove that they had that they met the due diligence bar. So the more common approach to defending Occupational Health and Safety Act charges are procedural strategies, which all come from criminal law, and they're such as Charter of Human Rights defenses, There are basically procedural strategies at the end of the day that either try to knock out the charges on a procedural mistake, which is very rare, or simply try to mitigate the fine, right? So the most common approach in these circumstances is reaching a deal with the Crown or the Justice of the Peace or the judge, whoever's presiding over it, to enter a plea deal based on either mitigating, aggravating factors, after you hire a lawyer that really knows the area and knows the cases and understands what fines are available in certain accidents. The size of the employer is really important. The empathy the employer showed, the amount of money the employer makes, the type of injury that happened, all are factors that assessed in the type of fine that comes down. So it's important to know that when dealing with the file, because most commonly you're going to be entering into a plea deal. Not always, but it is the most common approach. So some practical tips. We talked about some of this, but regular training and refreshers on health and safety policies, frequent internal audits, and hazard assessments to identify risks early, right? Again, have policies, implement them, right? As for the OHSA, policies are only as good as their implementation, right? Like I can't stress that enough, right? I've created beautiful policies with employers, right? And then how they implemented the training on the policies and the ability to monitor how those policies are implemented, that's where the miss was. Accident happens and they get the charges down the line, right? And some tips on preparing for the investigation: keep thorough records of safety measures, training, and equipment maintenance. Engage with the Ministry of Labor inspectors professionally and address concerns promptly. Hire counsel if you deem necessary to guide you through the process so you don't incriminate yourself. And notably, any serious injury of an employee almost always leads to charges under the Occupational Health and Safety Act, almost always. So with the compliance investigation merely being a tool to mount a case against the employer. So it's hard, I know it's hard to hear that you should comply, but I'm painting my guilt, but that's where potentially getting some guidance from counsel on the differences is important for sure. And just as to note, because it's important, that I talked about the Occupational Health and Safety Act a lot, but the Provincial Offences Act and these types of charges happen under a ton of different statutes, right, in the province, a lot of them. And the defense of them is the same for each one, subject to certain statutory differences, like I talked about in the Technical Safety Standards Act. That there's a distinct difference between the Occupational Health and Safety Act in when you can be charged and after an order. But for the most part, the procedural and substantive defenses available under the Occupational Health and Safety Act are mirrored in all of these different statutes that I've listed here, right? So Highway Traffic Act, Technical Safety Standards Act, Environmental Protection Act, Building Code, Smoke-Free Ontario, Dog Owners Liability, Trespass and Property Act, Liquor Licenses Act, Cannabis Control Act, Municipal Bylaws. Municipal Bylaws is a big one. Anytime I go to Provincial Offences Court, I always see in-house counsel for various public institutions that are just there dealing with like 5 or 10 municipal bylaw breaches at the same time as the Occupational Health and Safety and other breaches as well. So as for me and the Occ Health Act, that's it for me today. And I think we're going to jump in for the remainder of the time for questions. I think Lexa has the questions that have been asked by the group, if any, and we're more than happy to address those.
Yeah. So we've only, thanks, Phil. We haven't received too many. So if anyone else has any burning questions that they want to pop in the chat, please feel free to do so. One question I see here is that when documenting, is it better practice to inform an employee that this conversation is documented, or just do it in the background? So, you know, both. If you're giving it as a formal written warning that you want to rely on as progressive discipline, you should absolutely be letting the employee know, and you should be providing them with a copy of a written warning, or, you know, providing them with a record of the warning they've received. If it's technically a verbal warning, I still always recommend documenting that in writing. but keeping those records and providing them to the employee are really crucial. But also just keeping your own notes as well of any incidents that occur, just so you have a good timeline and a good understanding of a good record of what's happened and when. But ultimately, if you want to be able to rely on it as a progressive discipline, you should be providing that to the employee as well. So another question is, I'll let you answer this one, Phil. If an employee has been terminated for alcoholism, they have been given several opportunities to fix their issue, and they do indeed get sober, are there any legal obligations if the employee wanted to return back to the workplace?
So this is, huge disclaimer, not legal advice, because this interacts with, I'm sure whoever asked the question knows the Human Rights Code, which is a whole other aspect of terminations that we didn't really chat about here. And I'll start with the alcoholism at work and what happens there, right? If once an employer knows that someone is dealing with a mental health issue, which in Ontario and every other province, from my understanding, alcoholism is identified as a mental health issue, they have a duty to accommodate that individual at least once. Depending on the size of the employer, maybe more than once, right? Depending on how it affects the business, maybe more than once. And the standard rule we talk about with our employer clients is that you have to send them to treatment at least once, and they have to fulfill treatment. And then you could likely put them on a last chance agreement after the fact. And if they breach that last chance agreement, then termination is likely a valid approach, subject to guidance of counsel, subject to the size of the employer and many other factors that may require further accommodation, right? And then after the fact, if they've been let go or they left and they want to come back to the employer, it should be treated for the most part as a new hire, but then silently understanding that this person has this history, and the conversation can be had with them, right? The conversation can be had about expectations in the workplace and that you've been accommodated in the past, right? And have a distinct discussion with counsel, because it's a very sensitive topic, on whether you start the employee on some sort of last chance agreement or if you start afresh after the fact, right? Because the facts are really going to drive it. Like, just as with just cause, the facts of each case are going to drive the required accommodations in every circumstance. And hiring someone back that had alcoholism, which we know is a chronic issue that often leads to relapse and often leads to issues, but often leads to recovery too, right? So you can't paint everyone with one brush. So it's highly fact specific, and any return to the workplace should be guided well by someone who knows all the facts of the circumstances. But in general, to not avoid your question and to answer it directly, are there legal implications of hiring them back? Absolutely. Right, and they are everything I mentioned and potentially more.
Yeah, absolutely. That's definitely a tricky one. We've got another question that says, what would you recommend is the best way to dismiss for poor performance? Package the employee out? So again, it's going to depend on the circumstances. I know that's frustrating to hear, but it really does depend on the circumstances. I always, tell my clients that you don't even want to get into the progressive or the performance improvement plans and things like that if you don't genuinely want to give the employee a chance to improve. If there's other factors at play, if they're really just not the right person for the role, or they're not the right person for the organization, and you know that, don't put them on a performance improvement plan that you know they're going to fail. You really should be putting in a good faith effort to help them improve and succeed, right? If that's not the case, if you just ultimately, it's a number of factors, including poor performance. Typically, I again would suggest just terminating without cause, unless the poor performance is of such a high level that it could potentially justify termination with cause. If they're in a really high position of trust, if they have really high responsibilities in the organization, maybe financial responsibilities, things like that, and they've been negligent in their duties, that may be a consideration to think about going down the just cause route. But ultimately, if it's just, they're not really up to snuff, they're not really the right fit, then I would usually suggest terminating without cause and then providing them a package. But it depends on the circumstances. Also, if you have, this could be a whole other webinar, but if you have someone who has typically been a good performer and you see their performance just drop, that may, you may want to speak with them. They may be going through something, and that may engage your duties to accommodate under human rights law again, right? So that is something else to keep in mind. Yeah, so I think that's it for today. If there's any other questions, you can feel free to reach out to Phil or myself or anyone on our team. We'd be happy to discuss further. But otherwise, thanks everyone. We're finishing 5 minutes early, so 5 minutes back in your day. But thanks so much for joining us on this Wednesday. Well, wish it was Thursday, Wednesday morning. And thanks, Phil, for sharing your great experience with us.
Thank you so much, everyone, for having me, and thanks, Lexa, for hosting and your presentation. It was a pleasure. So, like Lexa said, reach out anytime, and have a lovely Wednesday, everyone.